And here comes the defendant, Ross Harris. He's in court. The judge is on the bench. The lawyers are there. Let's go in.
We're here on General Bill Indictment 14-93124, and we're ready for motions to suppress that have been specially set. The first matter are the Rule 22s, and I have them from the following outlets: NBC, CBS, WXIA, and Fox. Any objections from the state
We have no objection. We defer to the court.
and from the defendant?
We continue to raise the objection we raised previously to the matters.
That'll be noted for the record.
Thank
I'll
you.
sign them over those objections. All right. Are we ready to go forward?
State's ready.
We're ready to proceed, Your Honor.
We've been arguing for the defense, Mr. Wilson.
I am, Your Honor.
Very good. Please proceed, sir.
Could we, before we get started, if we, as the court has done previously, allow Mr. Harris to have his right hand released so that he can make notes, communicate with us?
I think we've done that before. I know that you filed an amended consolidated motion today.
I have not, Your Honor.
Oh, okay. All right. It was filed December 4th. We're in good shape.
If I have filed one, that's probably a very good one, Judge. That's
I'm sure it'll be excellent.
Thank you.
On the other hand,
On the other hand, Judge, just very briefly, just to give you an outline of where we're going here.
thank you.
The issue before the court is going to be the multiple searches and seizures that the state has executed upon Mr. Harris's property, that including items at his home, items in his car, items at his work, and potentially other items in other locations related thereto. Basically, Judge, what we're asking the court to look at here is to answer some very basic questions of what the Constitution protects any citizen here in our country against an unreasonable search and seizure without proper warrant. As the court looks into this evidence, you're going to hear, hopefully in chronological order as the investigation took place. I anticipate that's probably how the state will put up their evidence and how we will address it as well. Regarding the seizure initially from Mr. Harris of his cell phone, and then subsequent searching of that device, and then subsequently searching through his vehicle, through his home, through his work, through other locations involved with his work, excuse me, separate from his actual office. And basically, Judge, what we're asking the court to do is simply follow the law, that there's a requirement that in order for the state to seize a person and or a person's property and to search a person's property, that they follow the basic requirements, that they show that there is a valid warrant or there's some explanation and some legally justifiable excuse for not having a valid warrant. Specifically, we have in excess of 30 search warrants that were issued in this case. Because of that, this is a very tedious process in some extent, but I hope it's going to be a very interesting process for the court and for the parties as we look and see exactly what the state did and maybe more importantly what the state did not do in proceeding in these searches and seizures. I'm going to ask the court to answer the basic questions of, was there actual probable cause provided to a magistrate in order to allow issuance of search warrants? In providing that information, the court would also want to answer the question, was there misleading on behalf of the state in order to attempt to provide probable cause? The court would want to answer the question, why are there multiple times in which the state's not even attempting to provide probable cause to explain how there's any belief whatsoever that there would be evidence of the alleged crime to be located anywhere other than the instant location of the scene where this occurred? And is there any probable cause, or why is there no even attempt to provide probable cause to explain why there's believed to be certain items of evidence to be located in particular places? The state has the burden upon it in order to show that there was probable cause to believe there was other evidence, that there was evidence to be located in a particular place, that they actually provided that information to the magistrate, that they did not mislead the magistrate by material misrepresentations or by material omissions. And in the process of executing these warrants, how did they go about executing the search warrants? Even if they were valid, did they limit their execution of the search warrants to the specifics authorization of each search warrant? What we anticipate showing from the evidence, Judge, is that multiple people took part in these searches and seizures, specifically as it involves these electronic devices. This is a growing area of the law, and so Your Honor has a great opportunity, frankly, to make what I believe is a historical decision, good or bad. Unfortunately, me and the courts who have looked at this in the past have made decisions which continue to prove to be in error in allowing the state wide latitude in its securing and searching and seizing of devices without sufficient probable cause, and also allowing them to search those items well beyond the actual probable cause that may have been provided in those limited cases. As the courts are continuing to enforce the Constitution and make very clear that citizens do have rights against the state that will be enforced against unreasonable search and seizure, we're going to ask the court, when it's all said and done, to simply follow the law as we have it, as it's being shown to us by our Supreme Court, that in fact we're going to protect citizens over protecting the state. That's what we're asking the court to do, is look at this evidence, make a determination as to exactly, has the state met its burden? Have they done even the minimal requirements in order to go searching into another person's life and livelihood? As far as the actual evidence, Judge, I anticipate we'll have some witnesses, first of all, regarding the seizure of a phone from Mr. Harris, a chain of custody of how that phone got from him into police custody and ultimately how they searched it. I believe we'll have evidence of them executing multiple search warrants, again in multiple locations. And so we'll hear from, there's predominantly one detective who was responsible for securing most of these search warrants. I believe Detective Stoddard also secured a few of these as well. Detective Murphy, who's the one who's responsible for the majority of these. We'll be hearing from them very specifically as to what information he had and he gave to the magistrate in order to obtain a search warrant. We'll then be hearing from at least one, I presume multiple persons who actually did forensic analysis of these electronic devices to try to explain to the court how in fact they went about doing that searching, and were they limited in any way by either the search warrant, by the detectives, or by their own understanding of how these electronic devices work to limit a search to only what was being sought. At the end of the day, Your Honor, we're going to argue to the court, of course, what the law is, but I think the evidence will show is that they well exceeded, if any of these warrants even had sufficient probable cause, they well exceeded any probable cause in their searching because they simply wanted to look at Mr. Harris's life. They wanted to just go on a fishing expedition to see what they could find. And in essence, that's what produces evidence that the state now has before it. The Constitution says that's improper. The United States Supreme Court says that it's improper. Our Georgia Supreme Court says that it's improper. We believe Your Honor will say that's improper. That's why we're asking the court to sift through this evidence. We appreciate the patience the court will have. This is as I said, because of the nature of what we're dealing with, it is a lot of technical information. In order to make the record very clear, we will have lots of questions to make it as clear as possible exactly what we're dealing with. And at the end of the day, or at the end of the next 2 days, or if it takes a little bit longer, we'll put together how the law affects those facts and ask the court to in fact grant this motion to suppress, which is a consolidated motion considering each of these search warrants. Thank you, Your Honor.
Thank you very much.
Your Honor, I too